Afternoon, Allison Lukanich here from Basham Shaw, wanting to post a video. I've been getting a lot of questions and concerns. We're getting a lot of emails and people reaching out about what exactly is removal proceedings. What does it mean? What is going to happen? Is ICE going to show up on my door and deport me immediately? So, wanted to just clear up some of the mystery, talk about what it kind of looks like, what you can expect if you are placed in removal proceedings. So, first things first, in order to initiate removal proceedings against you, there are three separate agencies that have the ability to issue what's called the notice to appear. The notice to appear is a document, it's similar to an indictment in a criminal setting that lays out all of the charges against you and how you are either inadmissible to the country or deportable from the country. And I'll talk about the differences between inadmissibility and deportability in a moment. So the three agencies that can issue you a notice to appear are USCIS, CBP, and ICE. So, of those three agencies, it depends on what your immigration status is, what's kind of going on, how you quote unquote qualify to be deported, as to who will issue you the notice to appear. CBP primarily is going to issue notices to appear to those who are entering, possibly with a fraudulent visa. If they don't have a visa, if they're presenting at the border asking for asylum, for example, and are asking to be admitted for the purposes of seeking asylum. Sometimes CBP will issue notices to appear to individuals, green card holders who have been outside of the country for a very long time, and they're charging them with abandoning their green card. USCIS, on the other hand, will issue a notice to appear if you applied for a certain status and that status, that visa, that change of status was denied and your underlying status is no longer valid. If you're out of lawful status and they know it, they can and will issue a notice to appear. And ICE primarily issues notice to appear in the criminal context for immigrants who have been charged with crimes that may make them ineligible to remain in the United States. Also, as they're doing their fraud investigations, if your visa is revoked due to concerns, I know there's a big issue right now with F1 students getting their visas revoked, and ICE is primarily the agency involved in issuing those notices to appear. So, regardless of who issues the notice to appear, like I said, it's the indictment that charges you with your deportation. So it has factual allegations in it, and it also has, again, the charge under the law in the Immigration and Nationality Act of how you qualify to be removed from the United States. And I use the word deported a lot. Funny enough, since 1996, we no longer deport from the United States. We remove people. I guess it's just a nicer term, means the same thing. So, in terms of the notice to appear, the indictment, if you will charge you with either being inadmissible to the United States or deportable from the United States. The difference there is whether or not you have been lawfully admitted and inspected. So, typically, when CBP is issuing the notice to appear because you don't have valid travel documents, your visa is expired, something happens at the border, at the airport when you're trying to get in, they're going to charge you with a ground of inadmissibility because you've not yet been admitted into the country. Once you have been admitted and inspected, if you lose status, fall out of status, commit a crime that could result in your status being revoked, you would be considered deportable. So the notice to appear will include your charges of deportability, and those charges are based on the statute of law under the Immigration and Nationality Act of how you are, again, inadmissible or deportable. So what happens is, regardless of the agency that issues the notice to appear, it gets forwarded to the Office of Chief Counsel. They are the prosecution, the district attorney, if you will, of immigration court. They are a part of ICE, Immigration and Customs Enforcement. So regardless of the agency, they all send the notices to appear to the local ICE, the local OCC office in the immigration court that has jurisdiction over you, which is where you're living generally, or where you intend to live if you provide an address. And they make the decision to file it with the immigration court, which would thus initiate removal proceedings against you. So a lot of times what happens is an agency will issue a notice to appear against you. That does not mean that OCC, the ICE prosecution, will actually file that against you. Now, in prior administrations, OCC did a really great job of kind of weeding through cases and seeing, okay, what can we actually prosecute? Which of these cases can we uphold our burden under the law to be successful in? And who's not worth using our resources and taking our time because maybe the evidence is shaky, maybe we're not going to be successful on this, so it's not worth our effort and resources to pursue this case. And there were a lot of cases prior to 2016 where an individual would have a notice to appear, an NTA issued, and OCC would make the decision in a form of using their own prosecutorial discretion to not file that with the immigration court. Now, Trump administration, if you have an NTA, if it's been, properly served on you, you can almost surely bet that it's going to be filed with the immigration court. Sometimes they don't. You can, if you're working with a lawyer, sometimes it can be negotiated specifically where an individual has decided to leave the country affirmatively. They don't want to pursue the case, but more often than not, the case is filed with the immigration court. Once it's filed with the immigration court, at that moment is when removal proceedings are initiated against you. Um, it can take a lot of time. Sometimes I have prospective clients that had notices to appear issued against them. They freak out, they call me, they say, "What do I do? I need to get this fixed right now." It's like, well, it's probably going to take maybe a year before you hear anything else. And there's just panic in their face. Unfortunately, the courts are incredibly backlogged. When the Trump administration took away OCC's ability to use prosecutorial discretion to their advantage, the courts became insanely backlogged. There is an estimated 1.1 million cases before the immigration court of, again, inadmissible and deportable immigrants that the United States is trying to pursue their removal cases against them. And of course, there's only about 400 immigration judges, and these cases can take years to resolve. So what we're seeing now is after notice to appear is issued and after it is properly filed with the immigration court, it takes the immigration court sometimes 6 months, 12 months, or longer to file that in their case, just to open the case up in their system and issue the initial notice of hearing. So when that happens, they mail the respondent, you, the individual in removal proceedings, they mail you a notice of hearing. It has the date and the place and the time that you need to appear for your initial master calendar hearing. So there are two types of hearings in immigration proceedings. There's a master calendar hearing and there's an individual merits hearing. The master hearings are, you will often have multiple master hearings. Those are simply the initial hearings for the judge to review the case. If you have an attorney, they will often ask the attorney very straightforward questions to establish the NTA to make sure that those charges of inadmissibility or deportability can be upheld under the law, that those factual allegations against you are correct, and to investigate what relief from your removal or deportation will you be seeking. So it's not uncommon to have one, sometimes two, sometimes three different hearings where you're addressing the allegations in the NTA. You are establishing on the record what eligibility of relief from fight. Basically, how are you going to fight your deportation? What relief are you seeking before the immigration court? And then the judge will set deadlines to file those forms of relief. Again, it's doing a video on all of the possible defenses to fight a deportation. It would be a 4-hour video because there are very many types of defenses to fight a deportation. The purpose of this video is simply to discuss the procedures that happen. So if you are filing for relief before the immigration court, the judge will eventually, after you've established through various individual or master hearings rather, they will schedule your individual merits hearing. And that's when you appear with your attorney and it is your trial, if you will. That is when you are presenting evidence how you qualify for the relief. The OCC attorney, the prosecuting attorney will present any arguments they have for how you do not qualify for the relief, and the judge will eventually make his or her decision. When a final decision is entered into, if it is a negative decision, you have a 30-day window to appeal to the Board of Immigration, the BIA, the Board of Immigration appeals rather. And when you appeal to the board, when you're within that 30-day window, so long as you timely appeal, the decision by the underlying immigration judge in court is automatically stayed. That means that the order will not go into place for the 30-day window while you have to decide to appeal. And then if you timely file the appeal, it is stayed throughout the process that your appeal is pending. And that's just a rule because this is an administrative court. It is not a federal court. It is not a criminal court. It's not a family court like you may already be familiar with. It is an administrative court. So there are various appellate practices involved that kind of keep you safe while you kind of work out your options and figure out what you want to do. A lot of times, like I said, you can negotiate in advance if your visa status has been revoked due to whatever issue. Even if an NTA has been issued, sometimes you can communicate with OCC. You can work with an attorney on your behalf and say, hey, I'm planning to leave the country. I don't want to be accruing unlawful presence. I've purchase my ticket. As soon as I'm back in my home country, I'll show proof that I'm back home, and they will never, of course, file the notice to appear because you're no longer in the country. They can't pursue your deportation. So it's a lot of information today. It's a longer video, so please give me a call if you've been issued an NTA, if you have questions, if you are fearful that that might happen, give us a call. We'd be happy to kind of sit down, explain the process, and go through any specific defenses that you as an individual may have to fight your deportation. Thanks for listening in today, and look forward for more videos coming up in the next few weeks. Have a great day.